The Matrimonial Causes Act 1973 grants the courts enormous authority to redistribute assets upon divorce. A unified marital estate is systematically broken down into separate, reallocated pieces of capital, income, and pensions. State intervention on this scale requires strict structural control. The court cannot simply listen to adversarial arguments and arbitrarily divide wealth. Instead, the distribution of assets is governed by Part 9 of the Family Procedure Rules 2010. This framework imposes a rigid, iterative timeline designed to process the dispute through a series of highly controlled stages. The entire mechanism is activated by a single document, Form A. Filing Form A locks both parties into mandatory judicial case management. It starts a clock that neither side can easily stop, bringing every asset under the court's direct supervision. Mastering financial remedies requires understanding how to use Form A to engage this procedural machinery and systematically drive a case toward a binding resolution. The timeline actually begins before any paperwork is filed. The pre-application protocol phase expects parties to attempt voluntary disclosure and early negotiation. The court also imposes a statutory hurdle known as the Mediation Information and Assessment Meeting, or MEIM. If you attempt to file Form A without an authorized mediator's signature confirming attendance or a valid exemption, the court will outright reject the application. Once cleared, the practitioner submits Form A via the HMTCS portal, triggering the timetable. Notice the Prayer for Relief section. Practitioners tick every available box here, casting the widest possible net. This preserves the client's right to claim any financial order as facts develop. This immediate filing is often a defensive necessity against Section 28(3) of the Matrimonial Causes Act, known as the remarriage trap. If a client remarries before applying for financial relief, they are permanently barred from seeking capital or property adjustment orders. Issuing Form A safely circumvents this hazard, protecting the applicant's jurisdictional claims regardless of future marital status. The document serves two distinct functions. It proves compliance with the mediation requirement, and it acts as a legal shield for the applicant's claims as the formal timeline begins. Once Form A is issued, the rules mandate a massive evidence-gathering phase, culminating exactly 35 days before the first court hearing. This is achieved through Form E, the court's uncompromising mechanism for enforcing full financial transparency. The sheer volume of data required is extensive. Parties must detail their global assets and liabilities and provide hard evidence including recent payslips, P60s, mortgage statements, and property valuations. The duty of full, frank, and clear disclosure is an absolute ongoing obligation. It does not end when the form is filed. Any material changes must be continually updated. The courts enforce this duty rigorously. Landmark decisions in Livesey, Charland, and Goheel establish that any order based on incomplete or false information is inherently flawed. The judicial penalties for non-disclosure are severe. Judges will readily set aside final orders entirely and impose punitive costs against the offending party. The entire Part 9 machinery relies on the Form E phase to establish an accurate baseline of truth. Without it, the court cannot operate fairly or calculate an equitable division. With the evidence exchanged, the parties face the court for the first time at the First Appointment, or FDA. The FDA is strictly a case management hearing. No final judgments regarding asset division are made at this stage. The district judge's role here is to identify missing information, define the issues in dispute, and determine exactly what expert evidence is necessary to proceed. To prevent the costly friction of competing biased reports, the court utilizes Part 25 of the rules to instruct single joint experts. If a pension requires valuation, one actuary is instructed jointly by both sides. Under the Financial Remedies Court Efficiency Statement, opposing counsel must merge their data into unified joint documents, the ES1 for chronology and issues, and the ES2 for a combined schedule of assets and liabilities. By forcing both sides to agree on the raw facts in a single spreadsheet, the court saves massive amounts of judicial time that would otherwise be completely wasted arguing over basic accounting. If the parties can agree on these directions in advance, they can utilize the accelerated procedure bypass, completely skipping physical attendance at the FDA. The FDA acts as a critical procedural filter. It removes administrative friction and locks down the evidence required for serious negotiation. The pipeline then moves to a mandated negotiation phase, the Financial Dispute Resolution, or FDR appointment. The family procedure rules mandate this hearing purely to force the parties to use their best endeavors to negotiate a settlement. This hearing operates under the without prejudice rule. All offers, proposals, and concessions made during the FDR are privileged and cannot be used against the parties later if negotiations fail. The judge serves a unique function at the FDR. They review the privileged offers and provide an early neutral evaluation of what a final order might look like, applying direct pressure on both parties to reach an agreement. Because the FDR judge has been exposed to these privileged offers, a strict judicial firewall is erected. That specific judge is legally barred from ever presiding over a final hearing in the case. If the FDR succeeds, the immediate next step is to draft a detailed heads of agreement before leaving the building, which will later be converted into a formal consent order. The FDR is the true climax of the Part 9 rules. It is an engineered pressure cooker designed specifically to resolve the dispute entirely before a trial becomes necessary. Following the FDR, the timeline splits into two drastically different outcomes. If the FDR fails, the case heads toward a final hearing. This value state strips away the without prejudice protections and forces both sides to file open proposals detailing exactly what they will ask the court to order. A contested trial carries a heavy administrative burden. The parties must prepare extensive written evidence, carefully adhering to a strict 350-page limit for the trial bundle under Practice Direction 27A. The preferred outcome, however, avoids the trial entirely. Parties instead submit a consent order, drafted using standard precedents developed by Mr. Justice Peel, allowing the court to finalize the agreed division. A finalized consent order relies entirely on the structural foundation built in the preceding steps, the truth established by Form E, and the intense, privileged negotiations of the FDR. Part 9 is not a path designed to lead to trial. It is a sophisticated system engineered to force transparency and generate settlements. Strategic success depends on utilizing Form A to engage the specific machinery, using the procedural timeline to secure a fair and legally bulletproof resolution for the client.